Hi guys. Well, as promised, I got Derek 2, Derek Tran part 2 up. It took me a while. I got distracted. I get distracted easily, but it's pretty good. I actually got a compilation here of different people, and it's so funny and so annoying. And the poor judges and the poor prosecutors and the poor defenders, especially the defenders. I mean, could you imagine being a defender and your client? I want to plead guilty. That's funny. But um yeah, so if you like what you see, hit like and subscribe.
Derek Tran. Yeah. Okay.
And Becca Newsom on for today for Mr. Tran, who's appearing in custody from Nisqually Jail. There's two matters here that were on for motion. The first was 18L001530, and the next one was 23L000835. My colleagues, Ms. Pence and Ms. Hickok, have both been on this matter previously, and so after consulting with them, our office is requesting, disagrees with the finding of the recent evaluation. It made that record just last time in court, and at this time, our counsel is requesting that the court order a second competency evaluation.
Sorry, just a quick before we get too much into this. If you missed the first part, Derek Tran came into court last time, and it's in the last video, and he just right away, I want to plead guilty. I want to plead guilty. I want to plead guilty. And as everything was falling apart, and the defender is trying her best to defend him, he just keeps repeating it over and over and over again. That he just wants to plead guilty. They don't let him because apparently he had a competency exam before, and he like barely passed it. Like the bar was real low. So they said that they want another one. They want to make sure. Um, so they set another hearing for a couple days later, so they have a chance to talk to him, and they didn't do the second competency evaluation yet. They're still talking about it, but we get to hear why he's in jail now, and he's the same. He doesn't change. So yeah, now you know a little more.
Both my colleagues disagree with that finding based on conversations with Mr. Tran. And that's the basis for that request. I think at this time, the ask is that another hospital evaluator be ordered to evaluate Mr. Tran. Alternatively, we can also request funds for independent evaluation. But at this time, it looks like the evaluation or the request is for another competency evaluation.
I'll hear from the city.
And Your Honor, this isn't a situation I've specifically encountered. However, I believe that defense is representing that they still have concerns for competency and are making good faith representation that they have reason to doubt his competency. The city would not object at this time.
All right, I need your signature.
Yes, Your Honor, I'm just reviewing that right now.
Can I decline the competency?
No.
Can I decline?
No.
The court can note your statement, and then we can discuss. Okay? Well, we can discuss what your rights are with regarding to when the evaluation is being conducted. But
I'd like to hear from the parties regarding bail.
The city would ask for bail to remain as said. Right. The city has made a very thorough record several times in this case why bail is appropriate. for a multitude of reasons. The city is willing to revisit that again if Your Honor would like me to.
I would
However,
like you to make a record.
okay. Yes, Your Honor, this was a situation where there's been a series of cases filed for Mr. Tran prior to the current case that we are on. Most notably, the city notes that on May 17th, 2023, Mr. Tran was before the court. At that time, the city asked for a bail and a no contact order. That was ultimately denied by the court. Mr. Tran was booked back into custody 2 days later for assaulting the same alleged victim, that is Mr. Tran's father. This was a series of circumstances where these were purely cases that the city was not able to proceed on without the victim being on board. So the city was ultimately, did ultimately have to dismiss these cases. However, there's just been a pattern of assaultive behavior. The city did speak at length with Mr. Tran's father after the last time these cases were dismissed. At that point, Mr. Tran's father informed me that both himself and his wife were homeless and living in cars because they do not feel safe being in the same house as Derek Tran, who was living at their home. John, who is Mr. Tran's father, shared with me that he believes that if his son is on the street, he will die as he does not take care of himself. He doesn't shower and he doesn't sleep. And apparently, when he's at the house, he walks around all hours of the night, banging on things and threatening them. The victim did share multiple times with me that he is scared that Derek will severely hurt him or kill him, and that he feels that he has to remain homeless in order to protect himself from his son if his son is at his home. The city has concerns both for danger of violent crime, intimidation of witnesses, and interference with the administration of justice. I would ask a bail to remain on this matter as set, which I believe is currently the city requested $10,000 back at arraignment. It was imposed an amount of $5,000. The city would ask for that to remain.
10,000.
It's currently imposed in $5,000, but the city's request at arraignment was for $10,000.
And that is your request today?
Yes, Your Honor.
I'll hear from defense.
Your Honor, defense does request that the court consider a PR release from Mr. Tran in the opportunity to coordinate with our social services coordinator, Allison, who is back and available to us this week, and try to find out services and resources in the community so we can start getting Mr. Tran set up for a situation where we're not here before the court again. He is someone that would really benefit from that guidance.
Can I decline?
You decline?
Can I decline?
You may. I'm asking that the court release you. The judge will make the decision, though.
Okay, is that the end of your statement, Ms. Newsom? Okay.
Yes, Your Honor.
The court is concerned about the allegations that the city makes regarding Mr. Tran being released and booked regarding a pattern of assaultive behavior and the statement that Mr. Tran's father is actually afraid for his life and won't even stay at his own home because he is living in fear of Mr. Tran. The court does have concern for future dangerous or violent acts from Mr. Tran. And because of that, I am going to impose $10,000 cash or bond bail.
Okay.
I am going to allow another evaluation. As we all know, capacity competency is a fluid matter. It
Can I decline?
run one way one day and another way another day. And
Can I decline?
No.
I've heard you.
Can I ask a question?
Yes, you did decline.
Can I ask a question? Yeah. Can I decline?
Mr. Tran, the court has noted your position on this. So
Okay.
the judge is just going to finish with her court order, and then we can go from there, okay?
Well, I don't understand why you guys are giving me this. And, I want to speak to my attorney before all this, if that's okay.
Your attorney will be in touch with you after this
Okay.
hearing.
All right.
Okay, and so, the bail amount, again, is $10,000, and that will be on, cause number 23L000835.
Can I be released?
He just objected to that.
No? Can I please?
Mr. Tran, the judge just ordered bail. We did argue for release, but the judge declined that and has imposed bail. Your attorney will be in touch with you. She'll call you in the jail.
And then on, the earlier cause number 18L001530, release on that. Okay, let's see if it saves your, I made some changes. I need your signatures again.
On the order,
on the order for evaluation.
And I sign that again, Your Honor. Thank you.
I do see Ms. Hickok's signature, but let me see if it. Oh, okay. It's not. I'll try one more time.
Not saving, I can write it in. There we go.
Yep, there we go.
Is there anything else in this matter?
No, not from defense, Your Honor.
Mr. Tran's hearing is finished. Stay in touch with your attorney, Mr. Tran.
Bullseye.
Okay. Now, if you remember from the last video, if you saw it, Judge Mansfield she doesn't like noise. Like she wants a quiet courtroom. She wants things to go as they're supposed to go and not noise. Well, here we go.
Morning. It looks like this is Mr. Tia. This is number 23L000902. This matter comes on for arraignment. There are 2 counts of assault in the 4th degree domestic violence as a strangulation under Lakewood Municipal Court 9A12-130. I have advised Mr. Tia of the nature of the charges against him and the maximum penalties associated with those charges. Mr. Tia, I will advise you at this time, and I don't want you to respond to this information, but I need to advise you that one of these counts has a mandatory minimum penalty of 30 days. Mr. Tia is seeking appointment to our office. He gave me information that makes it clear that he's without a doubt eligible. He has no income at this time. We would stipulate to probable cause on both counts for the purposes of today's hearing only. Enter please.
He hit me first.
Enter please.
Okay,
Not
hold on a second. Mr. Tia, my
Yes, Your Honor.
I will ask you to remain silent unless asked a question.
Yes, ma'am.
Thank you.
Thank you, Judge. And I'll be asking the court to consider a PR release in this case, and I have some more information I can provide about that if needed.
All right. I will appoint Horwath Law to represent you, Mr. Tia. So you do have
The one on the left here?
I'm sorry, what?
Lisa is representing me or Kate McCrack is representing me?
Somebody from their firm, okay?
Which one? When? So I get released today or tomorrow?
Judge is getting there. Just sit tight.
Okay, yes, it's 90.
Right now, I'm just telling you that you have an attorney at no cost, and their information will be on the paperwork that you get today. Okay?
Yes, ma'am.
All right.
Your
Now
Honor.
I'll hear from the prosecutor concerning conditions of release.
Thank you.
Ms. Schumann.
Oh, I'm sorry, Your Honor. I was reviewing the criminal history, and it looks like there has been several charges of assault in the 4th degree, both domestic
All lie
violence
policy.
and
Remain silent, Mr. Tia. That is to your benefit. You need to remain silent right now.
Oh, sorry. My
Your
bad.
benefit.
I
Okay.
wrote that myself too. Play on.
domestic violence. Sorry.
The whole ag thing was a lie too.
Sir, can you?
Oh, sorry.
These charges have been dismissed, but there's resisting arrest, malicious mischief, domestic violence, assault in the 4th degree, at least 4 to 6 charges, negligent driving. He's been found guilty of. The other dismissed, no contact order violations, interference with reporting, and harassment. In this police report, specifically, the victims state that stated to the officer, and the officer wrote in the report that he has responded to this address multiple times, and quote, Lori and Afa, the 2 victims, said Michael frequently physically assaults Afa, and that this incident would be the last time. Afa repeated that he is finally setting his foot down and will be applying for a protection order. The city is asking for 2 no contact orders with each of the victims, both Lori and Afa, and the city is asking for bail in the amount of $5,000, given that this is a household that has had several calls to police officers that have resulted in charges being filed, and then the parents subsequently saying they're trying to work with crisis and mental health providers to de-escalate. And clearly the situation is escalating, not de-escalating. There is 1 count of strangulation, which is a serious count, and the city takes very seriously. I understand that these are not criminal charges, that are not convictions, but it does show a pattern of aggressive and increasingly aggressive behavior in this household. And I don't want to wait until there is a more serious problem. So I would like 2 no contact orders and $5,000 bail to be set.
And I certainly understand the city's concern, and that allegations are concerning, no doubt. And I believe that a 2 no contact orders are sufficient and appropriate here. That's a sufficient, less restrictive alternative to the imposition of money bail. Money bail is essentially a last resort in Washington. The city is correct in stating that Mr. Tia has 1 lifetime conviction, and that's a 2016 negligent driving in the 1st degree. He does have some other prior cases that resulted in dismissals as a result of deferral agreements, essentially. And that indicates to me that Mr. Tia has a willingness and an ability to comply with court orders. And that indicates
He can't even comply with be quiet. That's too much for him.
that he has an ability to comply with a no contact order, and he has the ability to comply with an order to return to court for an out of custody hearing. I also note that Mr. Tia has only 1 lifetime case with any FTA history, and that's the case with an incident date of 2016, and a number of other cases with dispositions without warrant history. So again, shows a willingness to comply with court orders, a willingness to return to court, to show up to court dates. I did discuss with Mr. Tia the likely imposition of a no contact order today. He's prepared to abide by that, and he has a plan for housing that won't put him in violation of those orders. So I would ask the court to simply impose a no contact order, not impose money bail today. If the court is inclined to impose bail, then I would ask that the court take into consideration, as 3.2 requires, Mr. Tia's individual financial circumstances, his indigency, the fact that he has absolutely no income whatsoever. And given that and the lack of history, I don't believe that any amount of bail is appropriate. But if Your Honor is inclined to impose bail, I would ask Your Honor to consider something in the neighborhood of $250 to $500.
Okay, one moment, please.
Thank you.
I think we get more of his foot. Don't worry. I can't tell what he's saying. I'm trying.
I will impose no contact orders in this case.
And I'm sorry, I would be requesting civil standbys. I think I forgot to state that. It's the address from
No
discovery.
objection. I've already put that in the no contact order.
Thank you.
Okay, and I'm going to ask the parties to let me finish my recitation. Okay.
Sorry, Your Honor. Thank you.
So as I said, I am imposing the no contact order in this case. And both parties do make very cogent arguments. While there is no indication of interference with administration of justice in the form of warrants or failures to appear that I can see, this court is concerned with the danger of future and violent crime. This court is especially concerned with the charge of strangulation in this case. Given that concern, the court will be imposing bail in the amount of $2,000 cash or bond.
Is that on each case or 1,000 on each case, 2,000?
It's $2,000 on the strangulation.
Oh, I'm the strangulation case. Thank you. Is the court imposing any bail on the other DV matter?
No,
Okay, thank you.
this court feels that that is the least restrictive means in this case. We'll have an in-custody pretrial looking at Wednesday, July 12th.
There it is. There's the foot.
I will set an out-of-custody pretrial. Did he be released? That will be August 1st at 2 p.m.
Maybe there's a psychiatrist in the crowd. Is that some kind of disorder where you have to just talk? You have to say little words every 3 seconds? I wonder if he has some kind of disorder like that. They're just filling out all their paperwork because that's what Judge Manfield likes.
Okay, sir, you are to have no criminal law violations, update any address changes with the court, use only your true legal name and date of birth, stay in touch with your attorney whose information is going to be on this paperwork, do not possess or own firearms, abide by all prohibited court orders, including the no contact order that I will be signing. I'm saving this document for review and signature, and I'm moving on to the no contact order. First one I see protects Lori Tia, date of birth 6/3/1959. Do not cause, attempt, or threaten to cause bodily injury to, assault, sexually assault, harass, stalk, or keep under surveillance the protected person. Do not contact the protected person directly, indirectly, in person, or through others by phone, mail, or electronic means, except for mailing or service of process court documents through a third party or contact by the defendant's lawyers. Do not knowingly enter, remain, or come within 1,000 feet of the 105th Avenue address. Do not obtain, own, possess, or control a firearm. This no contact order expires 5 years from today's date. Civil standbys to be completed by July 13th at the 105th Avenue Southwest address. I'm marking served on defendant, and I'm signing. Moving on to the next no contact order. This no contact order protects Afatia, date of birth 6/22/1952. Similarly, do not cause, attempt, or threaten to cause bodily injury to, assault, sexually assault, harass, stalk, or keep under surveillance the protected person. Do not contact the protected person directly, indirectly, in person, or through others by phone, mail, or electronic means, except for mailing or service of process of court documents through a third party or contact by the defendant's lawyer. Do not knowingly enter, remain, or come within 1,000 feet of the 105th Avenue address. Do not obtain, own, possess, or control a firearm. Civil standby similarly to be conducted by July 13th. I'm marking served on defendant, and I'm signing.
So if he doesn't make 2,000 bond and he has to do civil standby by the 13th, what if he doesn't get out? I guess they have to put a motion in. I don't know. I'm not a lawyer. You guys can tell me.
Having an issue signing. Moving back to the pretrial commitment release. Okay, I see Ms. McCracken has reviewed and signed this order.
The pretrial release order, Your Honor, I already signed it. Is it not showing up?
I just said, I see that you have.
Oh, my apologies. I misheard you. Thank you.
I'm marking served on defendant, and I am signing. Is there anything else in this matter?
Nothing from defense. Thank you very much.
The foot one more time,
Is
maybe?
there anything else in this, on this docket?
I don't see anything.
All right, thank you.
Addressing the respondent here because, Mr. Lovinger, I see, according to the record of service that it was filed with this case today, that you were served on Friday.
Okay. This poor guy has absolutely no clue about anything this entire time. He is absolutely clueless.
Under the rules, you're allowed more notice than that. So if you're not ready or prepared and need more time, I would give it to you. if you don't feel like you care about the short notice, then we can go ahead with your hearing.
You can go ahead, I think. Can you hear me?
I can.
All right.
Do you know what you would like to do?
No.
Sorry, it wasn't coming in very clearly there. So I'm sorry, Mr. Lovenger, could you repeat what it is you'd like to do?
I could sign the pink pieces of paper. Yeah. This stuff.
Okay, I'm not sure what you mean by that. Would you explain that?
The trespass warnings. Or
Okay.
is that what it's about?
No, it's not about a trespass warning. Ms. Grant has petitioned the court for a anti-harassment order against you. And that's the kind of hearing we're here for today. This doesn't have anything to do with a trespass warning.
Okay.
Did you read the papers that were served on you?
I got one of them. Temporary protection order.
Is that the only thing you read?
Yeah. And the Zoom link.
Explain.
No, not yet. Okay, so according to this return of service that the court received from an April Stowe, she served on you on Friday a reissuance of a temporary protection order. I don't see that any other documents were served by her. Okay, so let me ask you, Mr. Lovenger, did you receive a copy of the petition for an anti-harassment order that Ms. Grant filed with the court?
I don't think so.
You don't think so? I don't see proof that you, so you don't really know what this is about yet, do you?
No.
Okay, so you just came to court because you got this notice served on you by April Stowe?
Yeah.
Okay. Yeah, it's not about a trespass warning issue. This is Ms. Grant asking the court to issue an anti-harassment order that would have, if it was issued, would have some severe potential legal consequences for you. And you have a right to have notice of what that is and a right to be prepared and then be heard on it. And I'm a little bit concerned that you haven't gotten the proper notice and that you're not really prepared to respond to that petition.
Nope.
Yeah, that's kind of what I expected when I saw this return of service.
Don't worry. April will figure it out because she's mad.
Okay, so just hold on 1 second here, Mr. Lovenger. Ms. Grant, you wanted to say something.
He absolutely knows what this is about. He does. He was told. He trespassed on my property the first time, May 23rd. He then trespassed on my property again on June 15th when he was peering into my windows after being told to not come back to my property. I have documentation from neighbors. He was also served, his two adult brothers came and were in my neighborhood and requested to speak to me. I did exactly what I was supposed to do. I left court for the first time and drove to the Olympia Police Department. I provided the service papers be distributed by Olympia Police Department. I spoke to Angela Johnson in records. Olympia Police went to serve him at his home, and his mother, Linda Lovenger, answered the door and said, "Stephen is not here. He's being held in a mental health facility in Centralia." OPD then called me on my phone and said it is my responsibility to contact Centralia PD. I then called Centralia PD immediately, and I was told by Centralia PD that the only mental health facility he could be held in was called Maple Lane, that I was responsible for calling the Thurston County Sheriff's Department to have him serve him. I immediately did that. I was told they only had one deputy, but they would attempt. The sheriff went to serve him at the facility, and he was told he was not at that facility. A few days ago, a neighbor came and knocked on my door, a neighbor who provided a statement of what she has witnessed and experienced with Stephen in our neighborhood as well, and said his two adult brothers, David Levenger and Joel Levenger, are at another neighbor's house, and they would like to speak to me. I went across the street. I explained to them what Stephen has done to me on my property multiple times. I provided them with all the documentation that I received of the temporary no contact order. I explained that he had been harassing me. I explained he had court on Monday. I called they said he was not in Maple Valley. He was being held in Cascadia. I called Cascadia that day and asked if they would be willing to serve him. They said no. His adult brothers then called Cascadia and said, we would like you to serve him this paperwork. They said no. I had then called Olympia Police and was told, and they told them that he would be returning back home and he should be served. I have been trying for over 3 weeks with 2 different police departments and a sheriff's office to have him served. My neighbor, Dale Ray, walked over with April Stowe on Friday afternoon when we were told by his adult brother, Dan Levenger, Stephen is now home, you may go serve him. So Dale Ray walked across the street with April Stowe. April Stowe served him, and Dale Ray said, you need to leave him or her alone. Don't go over there. This is about you repeatedly going on her property. Stay away from her. So he fully understands what today is about, and he has had ample warning from his family, from the legal system. You know, I have tried. This is my 3rd time coming to court. I have tried endlessly. So he knows what this is. He knows he has been told repeatedly not to trespass on my property. I have statements from other neighbors who have told him not to trespass on my property, who I share the property
Ms.
with.
Grant, I'm going to kind of stop you right here.
Okay.
We're kind of getting back to where we started. Okay. Much of that, I have no doubt, is absolutely true, but not all of that is what's important at the moment. What's important at the moment, in order for this to be fair, and when I say fair, I'm using a colloquial term for a legal term called due process. Okay, and I am responsible under the law for making sure that everybody who comes into court and has a hearing has due process.
I understand.
That's what I'm doing. Now, I know that can turn out at times to be frustrating, and at times it can make things take longer than you feel that they should. I completely understand and sympathize with that.
I've also missed.
Yeah, I'm going to ask you not to interrupt me, okay?
Okay.
Mr. Levenger has a right to know what this is about in the legal sense. In other words, to have properly served on him notice sufficiently in advance so that he can come to court and have a fair hearing. I'm concerned because the record in this case shows that he was served on Friday. That's not enough time. Today's only Monday. And second, the service that was accomplished on him was not complete. Only a portion of what he's entitled to have notice of was served on him. He's not in a position to respond to this in a way that's fair. So as a result of that, I'm going to reset this hearing, give Mr. Levenger an opportunity to be ready to respond to the petition that was filed. As far as I know, hasn't been served on him yet.
Well, he wasn't home to be served until Friday afternoon.
Yeah. The date for that next hearing is going to be on the 24th, Kayla.
Yes.
Okay. And Mr. Levenger, you're not going to get any new notice. Nobody's going to give you another, nobody's going to come up and give you a written notice for hearing or, give you a call or an email or anything about this. This is your notice today. Okay, I'm telling you, and then I'm placing in your court file a written version of what I'm telling you, which is that your hearing is going to be on the 24th. And that document, I expect you will look in the court file, you will comply with, and that means your hearing is on the 24th, and the temporary order that the court previously issued for Ms. Grant is still in effect until then.
Okay.
You can make clear to him that he's not allowed to trespass on my property.
That's part of this order. So, yeah, Mr. Lovinger, you absolutely have to comply with the conditions of the order because you can be arrested if you don't.
Yes.
I just want to say that the 24th will be my 4th time attending court, and my son is missing vital medical appointments in order to make these. Because he has appointments Monday at 9 a.m. This is the 4th time he's having to miss a vital medical appointment because I'm a single parent who doesn't have anybody else to take him. So I take him back to the court to deal with this yet again. So this is seriously impeding my son's health.
Let me translate. She wants to speak to the manager.
In order to do this. And it's not as though we waited till the last minute to serve him Friday. He was not home. I made so many efforts to have him served.
So many.
I don't doubt that, Ms.
It took
Grant.
3 police departments
I don't doubt
and a
that.
sheriff's office.
I know.
And nobody would help me.
I know that this isn't easy to do,
No, it's not.
and
It's
sometimes
terrifying.
it takes.
Since May 23rd of this man.
Yes,
All right. Well, Ms. Grant, the hearing date's going to be on the 24th. You've got notice of it.
I mean, I don't know what he did. I don't know if he did anything wrong. It appears like he did. It appears like there's witnesses, letting her know that he's not doing great things around her house. And I don't think he's innocent, but I have no way of knowing. But I don't think she's scared of him right now.
Everybody knows now. Everybody has sufficient knowledge in advance of the hearing and what it's about. So we'll conduct that hearing and make a decision on the 24th. All right. Any questions, Mr. Lovinger?
Where do I find this stuff?
All right. We'll see you back here on the 24th.
Same room?
Same room.
At 9 a.m.? Yeah. Okay.
At 9 a.m.
Okay.
He's not done yet. Over. She's leaving. He doesn't know he's supposed to leave.
Do I need an attorney? Or what?
Yeah, that's entirely up to you, sir. You can hire an attorney if you'd like, or you can do this on your own if you like. That's your decision to make.
Is it advisable to do my own?
Absolutely. Yes. Do it on your own. Do it for YouTube.
Okay. Harmon. Okay. And would you let Chase know that reissuance that he needed is ready?
And he figured it out.
Okay.
I think I made a mistake. Oh, okay, then we go on to the next case. Okay. Sorry, I thought I recorded too much. I'll just start it here.
And, does she know that the interpreter is on her way?
I'm waiting to see.
This case had been, this is case number 23-135. this case resulted in the issuance of an anti-harassment order on May 22nd. At that time, the petitioner was present, and apparently the respondent was not. Later on June 2nd, looks like there was a request that the case, that the default be set aside, and it looks like that order was granted by Judge Pro Tem Hoffman.
So this is one of those cases where I want both of them to lose. I'm not happy with either of them.
According to Judge Pro Tem Hoffman's order, there was some confusion about the court date and the requirement to appear. And so he ordered, he ordered a full, the matter be heard on the merits, basically, but that the temporary order would remain in effect until today. And that sort of brings us up to where we are now.
But the way this judge handles her soon is amazing. It's my favorite part.
Okay. All right. So are both the parties ready to proceed?
Yes.
Yes.
Okay. You ready to go? Okay. Thank you. And what I'm going to do here in just a minute is I'm going to swear you both in. I'll let Mr. Freeland go first. Then after I've heard from him, I'll let Ms. Joyce tell her side of it and make a decision on whether the order continues past today. I'm going to ask you to both keep in mind that any material, written statements, anything else that you've submitted as part of this case is already part of the record of the case, and I've seen it and read it. So it's not necessary for you to fully repeat everything that you filed in the case.
Don't worry, they still will. They still will. We'll get to know exactly what they're thinking. And also, don't worry, he doesn't deliberate too long.
You can just summarize it or refer me to specific sections of it if you want to emphasize those. Okay. So can I have both of you raise your right hands? And do you both swear that the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. All right, Mr. Freeland, you get to go first. Go right ahead, sir.
So first I wanted to point out I was not properly served for this hearing. In her numerous attempts to contact me first, before even filing this with this court, she attempted to have her partner or whoever she lives with, who was previously told not to come on the property, had that person trespass over 6 different times in an attempt to serve legal documents, which the police even pointed out were not valid. And as seen in the evidence I have submitted before this hearing, the emails from the county court clerks actually prove that that is true, that those were not valid documents. And so he did not have a right to be on the property. Other than that, as far as her attempting to serve me by mail, I have seen no request for service by mail submitted to the court and filed in evidence, so I'm unsure if that was even allowed. Regardless of that, the proof of service for the mailing receipts indicates that not all the required documents were served to me. In addition to that, the next time she served me after that, or attempted to, was with another family member, which they have all been told they are not welcome on this property multiple times. And that is missing pages in the filing here. So there is no proof of service here that she has provided today that indicates I was properly served. In addition to this, she has submitted zero evidence to this court and has made numerous claims in order to get a continuance. The first time that she was told the wrong date. In my evidence I've submitted, as well as the audio recording of the initial hearing, that is completely false. At no point was the date that she mentioned ever even spoken of during that first hearing. And in addition to that, the judge said 7 different times when it would be held. She seemed to have enough time during that court hearing to interrupt the judge in order to give her own opinions, but for some reason she was unable to figure out the date there. That seems highly unlikely to me.
So as soon as he said that, I was on his side because I don't like anybody interrupting our judges. We love our judges. But still, I don't like him. I don't like her. I don't like him. I don't want either of them to win.
But it does seem to me that she's committed perjury in order to get this hearing today. I've submitted numerous things in my new evidence, including the fact that she lied multiple times now about when she was initially served. First, during the initial hearing, she was corrected by the judge immediately when she was incorrect about when she was served. And now on this latest filing, she has chosen to submit false information again about when she was served, as proven by not only the photograph, the email, but the affidavit from the process server that I used. She has essentially submitted false information here and used multiple attempts to serve documents in order to harass me again. There is nothing she has submitted here that gives any reason or just cause to negate this order and to strike it down. Everything she has to offer here today would be hearsay at this point, whereas I have submitted numerous forms of evidence showing that she has potentially committed perjury in order to get this hearing and has not properly served me at all.
Everything is hearsay. Everything.
And in addition, I wanted to point out even her service by mail, even if that was allowed by the courts, she submitted a proof of service for it, but that was never actually received at this address as proven by the tracking information I provided. So there is a plethora of false information coming from her side in order to get this hearing today. And I'm requesting that this be denied and the order remain in place, and if possible, extended for this. I believe she needs to face charges for lying to the courts in order to drag me here again with absolutely zero evidence.
Send her to jail.
All right, Ms. Joyce, you can tell me your side of it. And before you start, I'm going to tell you, you don't need to address the issues of whether this case should be here for a hearing. That decision was already made based on the pleadings by Judge Pro Tem Hoffman. So we are here to address the merits of it, and there's no need to readdress that, because I'm not making a decision here as to whether or not Judge Pro Tem Hoffman made the right decision. The decision I'm making is whether the order remains in place or not. So, Ms. Joyce, go right ahead.
Cool. You can give him his order, and you can give me an order against him as well. Okay. That's what I want, and that's what should be happening, because he's falsely accusing me of all these things when I have paperwork and emails from all of the people that work there, all of my stuff. And why would I write down May 30th if the judge didn't tell me May 30th? Okay. But I don't care. Give him his order, keep his order. I have a 12-foot fence or however big it is, so he can stay on his side. He can live his life, continue wearing dresses. I don't give a shit. Like, I'm so mad that he thinks that he can get away with all this stuff. I'm sorry. I'm so mad that he's sitting here saying that I'm a liar.
I want you to stop
I'm not
right
a liar.
there, Ms. Joyce. I want you to stop right there and take a breath. All right, I see where this is going. And this is what I'm going to do. I am going to leave the order in place as issued by Judge Pro Tem Laconin. And then, Ms. Joyce, to address the issue that you brought up, which is that you want an order to protect you from Mr. Freeland,
Correct.
that you can petition the court for that order. I can't just make it up at this point. You can file a petition for an anti-harassment order of your own.
I did. I absolutely did. This man has been harassing me, my family, ever since he moved in. He's had my bike stolen out of my yard.
Yes, definitely.
But like I said,
this man has been harassing me. I
Ms.
put in a
Joyce,
petition.
Joyce,
I don't know why you don't have it.
Do you have a case
petition.
number for your petition?
I guess not. I guess they gave me the same case number. I guess they didn't. That's not what they gave me.
Yeah, this case number is Mr. Freeland's petition. And if you want a petition, you need to draft one and file it for your own case, which you're free to do. You can do that at any time.
I will. I most certainly will. So we can miss
Okay,
one.
then my ruling on the issue before the court today is that the order as previously issued will remain in effect.
I have a question though. Could you ask him a question for me? Because
Ms. Joyce, maybe, but you got to let me finish and not interrupt me. All right.
I didn't mean to interrupt you. I'm sorry.
Is there another context where interrupting people who are in the middle of performing their jobs works? That's no different in court.
No,
you
sir.
simply can't do it. Okay. So the order will remain in effect. I don't see any reason to overturn the prior order, and it's being issued without objection. And it's going to remain on the same terms and conditions as it was originally issued, and that addresses the petitioner's request that it be extended. There isn't any basis for that.
Cool.
But I'll remind you, Mr. Freeland, that under the law, you've got the right to petition to extend or renew the order. And that's a process that you can do as the order is about to expire. And I'll just refer you to RCW 7.105 to decide when or if you want to do that. Now, Ms. Joyce, your question.
I need you to ask him how he got my name, my last name, and my boyfriend's name, because I think he did it fraudulently. I think he did it.
That.
Why not?
You can't. He's
That's not the proper role of the court. I'm sorry.
You can do it, Judge.
Okay, so he can have. Okay, all right. He did it fraudulently. Went through my mailbox. So he's harassing me. He's taking video of me and my children. Who's harassing who? From day one. I'm gonna file.
Ms. Joyce, I'm gonna end the hearing here today.
Cool.
You can file if you choose to do so.
She's gone.
That'll end the matter. Okay, the next case. Howard.
Okay, let me get my.
I see Miss Howard there, and I know you're logged in. Miss Wilson, do you have a camera?
Yeah, do you see it?
No, I hear you, and I see you logged in with your name, but I don't see an image.
Okay, let me get it going. Okay, there we go.
Okay, much better. Okay, I've got you both here now. Good. I've got your case, which is number 23-187, and this is Miss Wilson's petition for an anti-harassment order against Miss Howard. Again, I'll remind the both of you that all the material that's been submitted to the court file as part of your case, already part of the record and has been reviewed by the court. So Ms. Wilson's going to get to present her case first because she's the petitioner. Then Ms. Howard, you get to respond and tell me your side. After I've heard from both of you, I'll make a decision about the order. All right. So before we start, can I have you both raise your right hands, please?
Well, I'm sorry. I spoke with my advocate because I'm in a DV case with her son right now. And I was advised to ask if I could get a little more time for legal counsel.
Let's hold on what I was doing here a minute ago, and I'm going to address what Ms. Howard just brought up. All right. So, Ms. Howard, it sounds like you're asking for a continuance. Can you explain to me the basis that you think that you should have one?
Yes. So, like I said, I'm in a current running DV case with her son. I reached out to my advocate because I feel like I am being targeted. Some of the information in the report was false and was used in order to cover her son. So I just would like to seek a lawyer since I'm getting false accusations.
So you want to continue and so that you can explore the possibility of hiring a lawyer to represent you for this hearing?
Yes, please. I've talked to a couple of them already. I just haven't signed any contracts yet.
All right. So that's the request. Ms. Wilson, I'll ask you if you have any response to that, but I will tell you I'm pretty, I guess, generous in granting requests like that, but there may be a good reason not to. So go ahead.
I don't care if she does, but I want the temporary restraining order to hold because of her mental illness and her manicness. She did not just harass me, but ran my vehicle. And I was nice enough to tell the police that no, I didn't want her arrested and we were going to exchange information. So now I have an uninsured motorist claim on my car.
I'll assure you that I will extend the temporary order until the next hearing date.
And I want her to know that I will get an attorney too, and I'm going to go visit the police today because
you're certainly welcome to do that.
This is not false stuff. She's done this kind of stuff before.
That's funny because I met you one time and I'm not diagnosed with mental illness, ma'am. Don't act like you know me.
Well, then why are you harassing my neighborhood?
Ms. Wilson, mute Ms. Wilson's microphone too. Okay, now the clerk has muted both of your microphones so no one can hear any yelling that you're doing right now. And I did that because you're both kind of being a little disruptive and out of order here. So I want to explain to you what the possibilities are so that we can advance your case toward getting it resolved. And Ms. Howard has brought up a good reason to ask the court for a continuance, which would be so she can hire an attorney to represent her for this case, and that's perfectly valid. Ms. Wilson, it doesn't sound like you have any objection to that, as long as the court were to extend the temporary order so that you had the protection of that until the next hearing. And I think I advised you that I'm willing to do that. You also, of course, if it's what you want to do, can hire your own attorney to help you with this hearing, and that's perfectly fine. Your attorneys can represent you for this hearing.
The judge is praying that they both get attorneys so that he doesn't have to deal with this anymore.
Now, I'm not going to put up with or tolerate any more outbursts and disorderliness. It doesn't help the court make a decision in your case in any way. And I'm also going to ask you not to address each other directly, but just direct all of your comments to me. Okay. Now I'll have the clerk unmute your microphone because I want to make sure you understand this and there's not something I'm leaving out. But if you're going to be doing outbursts again, I'm just going to have the clerk mute you and then I'll tell you what's going to happen next. Okay. Do we both understand this?
Yes, Your Honor.
Okay. Now that's my intention is to reset this hearing for 2 weeks and extend the temporary order. Ms. Wilson, do you have any problem with doing it that way?
No, Your Honor.
Okay. Ms. Howard, do you understand what I'm saying here about extending the temporary order for 2 weeks?
Yes, sir. But can I actually ask you another question?
You can.
So I have no problem with there being an order in place. I have no reason to contact her. So I'm fine with that being put in place. My concern is that I work in healthcare and I don't want false accusations of substance abuse and mental health disorder When I was allowed their permission from her son, he was in my vehicle having a conversation with me. So I just, I don't know if putting thousands of dollars down on this is really worth fighting the order. So I'm curious what the stipulations are if you are to put this order in place, because I just don't want it to affect my career.
Well, I can tell you what would be on the order. That's easy. It's already on the order. So you just by looking at the temporary order, you would know. It's just the difference is it wouldn't be temporary. It would last for a year or potentially longer. But the second part of your question is maybe the more important one, and that is what effect that's going to have on you in other aspects of your life. And that I can't answer. And that is another reason that it's a good idea for you to talk to an attorney about it, because sometimes issues like these orders do have an effect on people's careers. So it's appropriate that you ask a lawyer that, not that you ask me that.
Okay.
All right. So then the order is in place as it was previously issued on June 26th, for the reason that you're asking to have a continuance to get counsel, which is perfectly acceptable. The next date is going to be on July 24th at 9:00 in the morning. Okay. Any more questions from either of you? Okay, we'll see you back here on July 24th.
Thank you.
Good morning, Mr. Williams. I'm Judge Vigorito here to explain your charges, your rights, and your options on how to get out of jail. You are charged with a Class B misdemeanor criminal trespass with a bond amount of $100.
All right, he's not dead. He's not asleep. He's awake. He just refused to come to court. So the bailiff walked the iPad up so that the judge can talk to him.
A Class B misdemeanor failure to identify yourself with a bond amount of $100, and a state jail felony evading arrest or detention with a bond amount of $500. Total amount of your bond is $700. Your bonds are so low because I know you're broke, but you're not going to get a personal bond, number one, because primarily because you refused to interview with them twice. So you're going to need to go through a bail bondsman or a lawyer or come up with $700. Now, if you don't bond out in the next couple of days, your court-appointed attorney, if you request one, will reach out to you in a day or two, and you can talk to them about what they could do to bond you out of jail. Now, these are criminal charges based on the sworn statement of a police officer. Doesn't mean you've been found guilty. You're presumed guilty until proven guilty. You do have certain rights under the Constitution in any criminal case, Mr. Williams. You have the right to remain silent. You don't have to make any statements about your case. If you give up your right to remain silent, whatever you say can be used against you. You have the right to hire a lawyer to represent you. If you don't have the money to hire your own attorney, you can request a court-appointed attorney. Mr. Williams, do you want a free lawyer to help you out?
I want you to call my home country.
What country is that?
China.
You want us to contact the Chinese consulate, let them know you're in custody?
Yeah.
No problem. Do you want a court-appointed attorney or do you want to hire your own lawyer?
I don't need either.
All right. So you don't want a court-appointed one. All right. If the police or the prosecutor want to talk to you about the facts of your case, you don't have to talk to them about it if you don't want to. If you choose to talk to them, you can end the interview at any time. You have the right to have a lawyer present during any discussion with the police or prosecutors about your case. You also have a right to a reasonable amount of time to talk with your lawyer before making any decisions about your case. One of these charges is a felony. On a felony, you have the right to request an examining trial. That's a preliminary hearing to argue that there's no probable cause, no reasonable basis to charge you with a crime. You could talk with your lawyer about that. You've already asked for the Chinese consulate to be notified. Lastly, if you're not from the United States, if you're not a U.S. citizen, you need to be aware that a conviction of a criminal offense can affect your immigration status, your right to be in this country, and your ability to become a naturalized citizen in the future. Mr. Williams, do you have any questions?
Yeah.
What is it?
What's the difference between separation of church from state and separation of state from church?
Well, that's not really what this hearing is about.
All right, have a good day. You're dismissed.
He's actually has his hands in his pants and doing things.
Bye.
All right.
So,
Bye.
are we done?
You know, I actually do have an answer.
Bye.
But we'll pass through.
Bye.
$2,000. Mr. Brito, you live in, where do you live? You live in Connecticut, right?
I live in East Austin. That's my address.
You live where?
On the east side of Austin.
Well, how long have you lived here?
I've lived here. My permanent address is my parents' address that I keep. Is that right?
Your parents live here?
I know the audio on this isn't great. I can't fix that, but it's still really good.
They live in Connecticut, so I live here.
How long have you lived here?
2 years.
A few years.
Yeah.
Well, that's certainly not the information that we were given. Who do you live with?
Just myself and my girlfriend and my dog.
Yourself and who else?
My girlfriend.
What's her name?
Melissa.
Melissa what?
H-A-A-R.
Huh?
H-A-A-R.
H-A-R?
H-A-A-A-R.
What's her phone number?
I do not know.
All right. I'm willing to consider you for a personal bond, but we have no references for you, and the information we have says that you live in Connecticut.
No, sir. It's I live in East Austin. It's 5602 Harold Court. I've been there for 4 years now.
What's the address again?
5602 Harold Court. East Austin.
Well, do you have anybody who we can call as a reference who can verify that?
Yeah, if I could get a number out of my phone, I thought I was just going to be here overnight. They told me to ask them if they can get it out.
Yeah, no, normally they tell you to write down any phone numbers you need because when they take away your phone, you're not going to have access to it. And so they tell you before they take it to write anything down. Did you write anything down?
I did not know. I thought I would be here overnight. I didn't realize
No, they generally tell you that before they take away your phone, that you need to write any numbers down you need because you're not going to be using your cell phone in a jail cell, you know? So you don't have anybody's phone number we can contact?
See my phone out there.
And you don't know your girlfriend's number?
I did not. She got a change recently.
Where do you work?
I work at Golden Bulls in West Austin. It's a bowling alley. I'm manager of a bowling alley and bowling bowl, it's called.
What's it called?
West Austin Bowl and Bowl. It's a
Bowl and Bowl. Well, the information we have is that you're a manager at a place called We. W-E.
I don't know where they got this information. I wasn't really asked much. I'm not sure what We is. But I can give you all the information that you need for anybody.
You can give me what?
Any information that you need or anybody else needs. I didn't really take anything from you.
Except the problem is all the information you're giving me doesn't line up with the information you already gave previously.
I never gave anybody that much that is.
How long have you been working with them?
I've been there, I just started 2 months ago, and then previously I was with the company downtown for the past year.
And how long were you there?
For about a year, previously.
You were there for about a year, and then you've been working at a new place for the last 2 months.
Correct.
But we say, our information that we got from you yesterday is that you're a manager at a company called We, and you've been there 5 years. I've never heard of the name of the company, but that's all the information we're getting. We're getting different address, we're getting different employer, different times.
I'm sorry, sir. I mean, my license does say Connecticut, but they never asked for my actual address. I can explain by that. I did need to get that changed. It was just a lot easier for me to do at the time because of COVID to my parents' address rather than get my license switched over to my current address where I
You have money in your safe. You have money in your checking account.
I do.
How much?
Probably right now. I know I have more in the savings. But,
how much?
I have more in my savings account, but I probably have a few hundred in the checking, maybe 20 grand in the savings.
And how much in checking?
Maybe 200, 300 maybe.
Okay, because you apparently you told the pretrial officer you had 10,000 in your checking account. I mean, it's like every single thing that I'm asking you, you gave different information to the pretrial officer. What's going on?
I'm sorry, sir. You know, this is not my school class night. Saturday night, I guess, on 6th Street, and then I did freaking drive. I made the mistake. So, I mean, I'm not sure. I definitely don't think I gave you as a name. But if I did, that's not where I work. I've been here for years living in Austin. I rent on the east side. I've been managing business for a year. And now this business for the last 2 months. I haven't gotten in trouble the past 10 years.
You mean since the case in Florida?
That was Robin's mistake. Yes. That's it.
And you don't have anybody at all we can call as a reference? Nobody?
If I could somehow get my phone, I could call.
Well, did they tell you to write down the numbers you needed?
They did, yes.
And you just didn't write anything down?
It was going to be released within a certain time. I didn't think it was going to be that extensive. I thought I'd probably do this in the morning or something, so I just didn't. I chose not to. That's my mistake.
All right. Well, right now I'm not comfortable doing a personal bond because I can't confirm any information at all, and the information you're telling me is different from all the information you told somebody else. So, do you want a court-appointed attorney, or do you want to hire your own lawyer?
Go for the plan for now. So if any way to get, I don't have a way to call anybody to get out today. If there's any way you can.
Well, I want to be able to call somebody so that if we could verify your information, I'll let you out on a personal bond. I prefer people not being in jail while their case is pending if we can avoid it. But I need to know that we got accurate information and you're going to show up for court, and all the information that we're getting seems to be changing by the hour. So, well, you need to take seriously when a deputy tells you to write down the phone numbers you need. You need to take that seriously. I mean, well, here's the thing. Your bond amount set at $2,000. Does your girlfriend know you're in jail?
Yes.
Okay, good. So your girlfriend knows you're in jail, and so, but I'm sure she'll be contacting the court, the courthouse, the jail, trying to figure out what to do, and they will direct her to contact the pretrial services office, perhaps, about getting a personal bond.
Okay, who thinks he even has a girlfriend? He doesn't. There's no way. No one's coming for him.
And if she can verify all your information, then it's possible that I'll give you a personal bond. She could also go through a bail bond company. They'll charge usually about 10%. In this case, it'd be around $200. Okay. So I don't rule out a personal bond. Hopefully she'll try to get a hold of us. If for some reason you don't bond out in the next day or two, then your court-appointed attorney will reach out to you, and you can also talk to them about what they could do to bond you out. They can come talk to me, and they'll know exactly the questions that I'll be asking. And you could tell them about our interaction so that they know what it is that I need. So, all right. You need to make sure you show up for all your court dates if you bond out, okay? You can call a bail bondsman. You don't have to wait for your girlfriend. You can call a bail bondsman. There's a list of bail bond companies on the wall next to the phone at your post. Some bail bondsmen don't collect calls from the jail, And it's usually much easier to make those arrangements through somebody on the outside. So hopefully your girlfriend's already working on that though.
Nope, she's not.
She had told that she met a police officer that night. They called her and she said she was probably leaving me. So this is a DUI. So I know I'm just not confident in that.
You understand you need to show up for all your court dates? All right. All right. Good luck.
Okay. If you made it this far, those were the good ones. This last one's 11 minutes long and 10 minutes long, actually. And I just left it in here, not because it's real good, but because this interpreter is crazy. She made me laugh the whole time I was watching her. Nothing funny happens. I don't know. It's just this interpreter. So you don't have to stay for the interpreter if you don't want to. She's just very animated and I enjoyed her. So I left her in here for anybody who wants to see it. But if you don't stay, thank you so much for coming out today. I hope you enjoyed Derek Tran. I did. If you did, like and subscribe.
Flores. Ponga atención, le van a hablar el juez.
Wilfredo Flores, I'm the judge here to explain your charges, your rights, and your options on how to get out of jail.
Señor Torres, soy aquí el juez. Estoy aquí para decirle de cuál es su cargo, de cuáles son sus derechos y de cómo puede hacer para salir de la cárcel.
Gracias. Mr. Flores, you're charged with a Class A misdemeanor criminal trespass of a habitation.
Señor, usted está acusado de una clase A delito menor por haber entrado en un lugar donde no debía.
Sí, señora, solo simplemente. Your bond amount on that case is $500.
Su fianza es $500, señor.
You're also charged with a Class A misdemeanor criminal mischief for damaging property.
¿Puedo pagarla en partes? Momento, escuche. Tiene otro cargo más. Número 2, cargo 2. Por daños y perjuicios, por haber hecho daños en el lugar.
Ok, ¿puedo hablar?
No.
De preguntar ahorita el último. Ok, está bien, gracias, discúlpame.
Your bond amount on the second charge for damaging property is $1,000.
Y el segundo cargo, que por haber dañado la propiedad, es de $1,000.
Now these are criminal charges. No.
No.
Okay. These are criminal charges based on the sworn statement of a police officer.
Estos son delitos penales, son delitos criminales que han... No, momento, escuche. Esto ha sido a través de un oficial de policía que ha venido y ha dicho que usted ha cometido este delito.
You will have an opportunity to talk to a lawyer before making any decisions about how to handle your case.
Le van a dar la oportunidad de hablar con un abogado antes de tomar cualquier declaración y cualquier decisión en su caso.
Now, Mr. Flores, you have certain rights under the Constitution in any criminal case.
En cada caso penal, usted tiene derechos constitucionales.
Gracias.
Well, you have the right to remain silent. You don't have to make any statements about your case.
Tiene el derecho a guardar silencio, no tiene que hacer ninguna declaración acerca de su caso.
If you give up your right to remain silent, whatever you say can be used against you.
Si usted renuncia si usted quiere hablar acerca de su caso, cualquier cosa que diga puede ser usada en contra suya.
You have the right to hire a lawyer to represent you.
Tiene el derecho a tener un abogado que lo represente.
If you don't have the money to hire your own attorney, you can request a court-appointed lawyer.
Tiene el derecho a contratar a su propio abogado, pero si no tiene dinero para contratar a un abogado, puede solicitar que le den un abogado que no le cueste, nombrado por el tribunal.
Would you like a free lawyer or do you want to hire your own lawyer?
¿Quiere que le den un abogado gratis o va usted a contratar a su propio abogado?
Quiero un abogado gratis porque no tengo dinero, tengo trabajo, pero una pregunta, ¿puedo pagar mi fianza por parte?
Momento, déjeme decir esto. Ok, momento. I want an appointed attorney.
All right. If the police or the prosecutor want to talk to you about the facts of your case, you don't have to talk to them about it if you don't want to.
Si la policía o los abogados del Estado quieren hablar con usted acerca de su caso, usted no tiene que hablar con ellos si no quiere.
If you choose to talk to them, you can end the interview at any time.
Si usted quiere hablar con ellos, puede terminar la entrevista en cualquier momento.
And you have the right to have a lawyer present during any discussion with the police or prosecutors about your case.
Y le van a dar un tiempo y una oportunidad para hablar con su abogado acerca de su caso.
You also have a right to a reasonable amount of time to talk with your lawyer before
También le van a dar tiempo para que hable con el abogado. Y puede tener al abogado presente cuando hable con los policías o los abogados del Estado.
Now, if you're not a U.S. citizen, you need to be aware that a conviction of a criminal offense can affect your immigration status, right to be in this country, and your ability to become a naturalized citizen in the future.
¿Puedo hacer una pregunta?
No, espere, escuche. Si no es ciudadano americano, la declaración de culpabilidad puede resultar en que tenga problemas con la inmigración, que no le permitan estar en este país o que lo deporten.
And lastly, if you're not from the United States, you have the right to request and contact the embassy of your home country and let them know that you're here.
Y por último, si usted no es ciudadano americano, tiene el derecho a que el juez le comunique a la embajada de su país que usted está aquí en la cárcel.
Do you want us to contact the embassy of any other country?
¿Usted quiere que llame a la embajada de su país para decirle que está aquí en la cárcel?
No. Necesito una llamada para hablarle a mi madre para que pague mi fianza.
I just need to make a phone call to call my mom to pay my bond.
No problem. You will have an opportunity to use the phone soon. Your bond amounts total $1,500.
No hay problema. Le van a dar la oportunidad de hablar por teléfono, señor, para que usted llame por teléfono y su fianza es $1,500.
Now, if somebody comes down to the jail with the full $1,500, you will be released. And as long as you show up for all of your court dates, at the end of your case, you'll get your money back.
Señor, si a usted pone los $1,500, alguien viene, pone los $1,500, lo van a dejar salir de la cárcel.
Necesito la llamada.
I need to make a phone call.
Okay. You'll have an opportunity in just a little bit.
En un momento lo van a dejar hacer una llamada, señor.
Okay. ¿Puedo hacer una pregunta?
May I ask a question? May I ask a question?
Yes.
Sí.
Ok, discúlpenme. El daño que me están expresando no lo quebré yo, simplemente me lo están acumulando, porque el oficial de policía está seguro que yo no lo quebré. Él sabe que yo no lo quebré. Él está de testigo.
They're saying the damage that I have done is not true. The officer knows that I didn't break anything.
Well, you could certainly talk to your lawyer about that. You do have the right to fight your case.
Usted tiene el derecho a pelear su causa. Hable con su abogado para esto.
But I can tell you from reading the police report that I do agree.
¿Puedo hacer otra pregunta?
Is sufficient evidence to charge you.
¿Qué otra forma tengo para pagar mi fianza por parte?
Ok, escuche lo que el juez le dijo, señor. El juez dijo que leyó la declaración jurada, con lo que el policía dice. Él tiene motivo fundado para creer que usted rompió. Pero hable con su abogado. Can I ask another question?
Yeah.
Sí, señor. Pregunte. I don't know where he is. Okay. Yeah. Señor, ¿cuál era su pregunta?
Bueno, mi pregunta es ¿qué se puede pagar en mi fianza por partes?
May I make payments? May I make payments?
Oye, no, mire, discúlpenme, con todo respeto. Yo no tengo un sueldo de empresario. No puedo.
I don't have it big. I don't make a lot of money. So I don't have those money.
Well, if you don't have someone to come down with the full 1,500, then your other options is to go through a bail bondsman. Your other options is to go through a bail bond company or an attorney.
Adelante justo para alimentar a mi hija, mantenerla y ahora como.
I didn't go to school and I don't
Right.
Gano 100 de trabajo diario.
You can hire a bail bondsman or a lawyer, and a bail bondsman will often do this, bond you out for sometimes 10% of the bond amount, which would be $150.
Señor, escúcheme. Usted puede llamar a una compañía de fianzas o puede llamar a un abogado. Ellos le van a cobrar, la compañía de fianzas cobra 10%. Y si su fianza es $1,500, puede ser que le cobren $150 para salir.
Tell your mom about that.
Cuando hable con su mamá, dígale a su mamá esto. ¿Comprendió?
And finally, your court-appointed attorney, if you don't bond out, they'll reach out to you in the next couple of days, and you can talk to them about what they could do to get you out of jail.
También, si en 2 días no sale, lo va a venir a ver un abogado. Y dígale al abogado para que el abogado lo ayude.
Okay.
Okay, ¿comprendió?
Okay, muchas gracias. Tengan feliz día, que Papito Dios me los cuide, me le dé muchas bendiciones. Salud.
Okay. Lot of blessings, Your Honor. Have a very good day.
You do. You too.
La llamada. Una llamada.
If you get out,
make a phone call.
If you get out of jail, make sure you show up for all your court dates. Right. Okay. Thank you, Sylvia.
Bye, Your Honor. See you later.
Have a great week.
Bye, Sylvia. Thanks for signing us off tonight. She was so funny. I don't know how many people are still watching right now, but she was so funny. I loved her. Yeah, that was a good one. That poor Judge Mansfield. She doesn't like noise, and that's all she got for the last 2 days is noise. And then that guy who wouldn't stop talking was so funny. I wonder what he was saying when he was muted. I mean, it was just little things under his breath, but oh my gosh. Well, I hope you enjoyed these videos today. I'm gonna put this one up and get some more ready for tomorrow. See you guys.